Tonight, we revisit one case that produced a single statute still preserved in the public record of the United Kingdom, the Sale of Arsenic Act of 1851. The conviction of a labourer's wife at the Essex Lent Assizes in the spring of that year drew the attention of Parliament, the press, and the medical profession to a substance that had stood for decades in every kitchen, every farmyard, and every village chemist's shop without restriction. One woman, one sack of rice, one trial that entered the national record and has remained there. The case of Sarah Chesham begins in the village of Clavering, in the northwestern corner of the county of Essex, in the closing years of the 1840s. Clavering lies in the hundred of Uttlesford, situated some 4 miles to the southeast of Newport and approximately 8 miles to the northeast of Bishop's Stortford, with Saffron Walden a further distance to the northeast and the county town of Chelmsford lying off to the southeast at a road distance considerably greater. London, the capital, was approachable from the parish only by Long Road or by the more recent option of rail. The Northern and Eastern Railway had been extended through Bishop's Stortford and on to Newport and Cambridge in the middle years of the 1840s, providing the first direct line of communication between this corner of northwest Essex and Bishopsgate Station in the metropolis. But Clavering itself sat at a distance from any platform and continued to depend, as it had for centuries, on cart, on foot, and on the long correspondence of country lanes that bound it to the market towns of Saffron Walden, Bishop's Stortford, and Newport. The parish supported, in the official census return of 1841, a resident population in the region of 1,000 souls, recorded as engaged predominantly in agricultural labour. The land was held in the main by a small number of landowners and tenanted by farmers who in turn employed the bulk of the working population as day labourers, ploughmen, shepherds, or in the trades attendant on the agricultural economy, smithy, wheelwright, miller, brewer, baker, and innkeeper. The character of the village was that of a working parish of northwest Essex, indistinguishable in its essential features from 100 neighbouring places. A single principal street running east to west, threaded by lanes and footways, with the more loosely scattered hamlets of Stickling Green, Starling's Green, Mill End, and Deer's Green sitting at the parish margins. The parish church of St. Mary and St. Clement, standing at the eastern end of the village and of medieval foundation, served as the formal centre of communal life, with the parish register reaching back, in unbroken sequence, to the 16th century. The Old Bell public house stood near the churchyard, and the small parish school sat within the same compass. The character of the streets was that of an unpaved country village, dust in summer, mud in the winter months, with the cottages built of timber framing, infilled with brick or lath, roofed with tile or thatch, each provided with a single chimney and a small garden plot. The principal industries were arable farming, the keeping of livestock, and the small-scale local trades that supported these. Wages for an agricultural labourer in North Essex in this period stood, by the surviving wage returns, at somewhere between 9 and 12 shillings the week, a sum that supported a family only meagrely and left no margin for illness, for the failure of a harvest, or for the additional cost of a funeral. The years now known to historians as the hungry forties had pressed upon the rural poor of southern England with particular weight, and the cottagers of Clavering were not exempt from this pressure. Poor relief, administered through the parish vestry and the Newport Union Workhouse, stood between the labouring household and destitution, supplemented by a small number of charitable bequests of long standing and by the irregular charity of the more prosperous farmers. The cottages of the parish, of which there were perhaps 300 occupied at the date in question, were of the common North Essex pattern, low-ceilinged, brick-floored in the principal room and earthen elsewhere, with one or at most 2 rooms upstairs reached by a narrow stair, a small range or open hearth for cooking, and a sack or barrel stood somewhere in the kitchen for the keeping of the household's provision of rice, flour, or oats. At one such cottage, known locally as Pond's Cottages and situated within the parish of Clavering, a farm labourer and his wife had brought up 6 children. The cottage was of the common pattern. A sack of rice stood against the inside wall. The case of Sarah Chesham, as it was finally adjudicated at the Essex Lent Assizes of 1851, returned its conviction in respect of one named victim, the labourer's husband, Richard Chesham. The full chronology of the matter, however, involves more than one death, and the surviving record of the case, in its press coverage, in its trial transcripts, and in the modern historical literature, has placed beside the name of Richard Chesham the names of 3 further persons whose deaths formed part of the larger inquiry. 2 of the children of the household, Joseph Chesham and James Chesham, and an infant of the parish, Solomon Taylor. The proceedings of 1847 had concerned themselves with these 3. The proceedings of 1851 returned to the household and concluded with the death of the husband. For the purposes of the present account, the Chesham household must be considered as a whole, and the persons whose deaths were the subjects of the various indictments must be introduced in the order in which the record received them. Richard Chesham was, by the parish records and by the testimony given at the proceedings that followed, a farm labourer of the parish of Clavering. His date of birth is recorded in the parish register as falling in the year 1807. He was therefore in his early 40s at the date of his final illness. He had married Sarah Parker, also of the parish, in July of the year 1828, at the parish church of St. Mary and St. Clement. The marriage register records that he signed by mark, as did his bride. The available primary sources do not preserve any detailed account of his early life, of his parentage, or of his occupational history, beyond the general entry of agricultural labourer against his name in the census returns of 1841 and 1851. He stood, in the social grade of the rural population, at the lower end of the labouring poor. The marriage produced a daughter, Harriet, baptized on the 8th of February 1829, and thereafter 5 sons in succession: Philip, born about 1830, John, born about 1832, Joseph, baptized about 1834, James, baptized about 1837, and George, born about 1839. The household at Pond's Cottages was therefore, by the middle 1840s, supporting 2 parents and 6 children on the wages of a single agricultural labourer, supplemented, where possible, by such occasional earnings as the wife and the older children could obtain through gleaning, charring, or the casual labour available at harvest. The financial pressure on the household in the years that followed the disastrous harvests of the early 1840s may be inferred from the general condition of the rural labouring class in the period. It is not, in respect of the Cheshams specifically, recorded in any document recovered from the surviving sources. Of Joseph Chesham, who would become the named subject of one of the indictments of 1847, the record establishes only that he was the 4th child of the marriage, baptized at the parish church in the middle 1830s, and that he was a boy of approximately 10 years of age at the date of his death in January 1845. Of James Chesham, the 5th child of the marriage, the record establishes only that he was baptized at the parish church in the later 1830s, and that he was a boy of approximately 8 years of age at the date of his death, which occurred within a few days of his elder brother's, in the same month of the same year. The 2 boys were buried in a single coffin in the churchyard of St. Mary and St. Clement, in accordance with what the surviving accounts describe as the household circumstances. The infant Solomon Taylor, whose death in the summer of 1846 became the 3rd of the deaths considered at the 1847 proceedings, was the illegitimate son of one Lydia Taylor, a young woman of the parish. The record offers little of his short life, beyond the testimony given by his mother at the subsequent trial. He had been born healthy. He had been, on the day before his death, in the company of Sarah Chesham, who, according to Lydia Taylor's evidence, had fed him with rice pudding and apple turnover. He had deteriorated rapidly and died within hours. He was, at the date of his death, only some months old. These four persons, Joseph Chesham, James Chesham, Solomon Taylor, and Richard Chesham, formed the human substance of the inquiry that the courts and the press of England would pursue over the 6 years from the spring of 1845 to the spring of 1851. The relationship that bound them all to a single suspect is the relationship that the proceedings would now address. If you find value in stories preserved this way, consider liking the video and subscribing to the channel, and let me know in the comments where you are listening from. Now, back to the record. Sarah Chesham, the woman whose name would become attached to the proceedings, was born Sarah Parker at Clavering on the 9th of July, 1809. She was, on the testimony of the census returns and the parish records, a native of the parish, of labouring stock and illiterate. The marriage register of 1828 records her signature as it records her husband's by mark. Her precise parentage is not established with the same degree of certainty as her husband's in the secondary literature, though she is recorded as the daughter of a labouring family of the same parish. She was 19 years of age at the date of her marriage, already pregnant with the daughter Harriet, who would be baptized in the February following. In the years between her marriage and the events of 1845, the record of Sarah Chesham's life is the silent record of a labouring wife of the period. She bore 6 children, brought them up at Pond's cottages, contributed such labour as the household required and as the local economy made available, attended church, and was known to her neighbours. The available sources offer no contemporary description of her appearance, of her domestic habits, or of her character at this stage of her life. The descriptions that survive in the press reports of the later 1840s and in the broadside ballads that circulated after her conviction derive from the period when she had become a public figure of notoriety, and must be understood as representations of that public figure, rather than as independent assessments of the woman. By the proceedings of 1847, the record establishes that Sarah Chesham had acquired a reputation in her parish. The Times, in reporting on her trial and acquittal, described her as an accepted and reputed murderess. Other newspapers, in the same period, accused the inhabitants of her parish of being complicit in her activities, of suspecting her, and yet declining to report her to the magistrates. After her acquittal of the 3 indictments of 1847, the surviving accounts record that she was met in the village street with the cry of "Sale Arsenic," and that she was ostracized by her neighbours. Whether this represented the village's settled opinion of her conduct, or the village's response to the publicity that had attended her trial, the record does not finally determine. Her relationship to the persons whose deaths formed the subjects of the various indictments was, in each case, the relationship of a person who had access. Joseph Chesham and James Chesham were her own sons. Richard Chesham was her husband. Solomon Taylor, the infant, was the child of a woman of the same parish, and the proceedings established that Sarah Chesham was in the habit of attending upon Lydia Taylor and her infant in the days preceding his death. The motive that the prosecution would in due course attribute to her in the case of the children was the financial pressure of a labouring household upon which the cost of 6 children pressed beyond the capacity of the wages received. In the case of her husband, the prosecution would suggest a different motive, a desire to be rid of a dying man whose illness she expected to end his life in any case, and whose suffering she had decided to terminate by her own hand. These motives must be understood as the constructions of the prosecution, supported in some particulars by the surrounding evidence and contested in others. The record does not preserve any statement from Sarah Chesham herself, made in confession, that confirms either motive. No prior criminal history attaches to her name in any record recovered. Her appearance at the Chelmsford Lent Assizes of 1847 was her first appearance before any court of higher jurisdiction. Her appearance at the same court in 1851 was her second. There was no third. The proceedings that followed concerned themselves with three distinct episodes, separated in time by months and by years, and connected, in the prosecution's case, only by the household in which the first and the third had occurred, and by the person who had had access to all three. They are best described in the order of their occurrence. The first episode opened in the early days of January 1845. Joseph Chesham, then about 10 years of age, and James Chesham, then about 8, fell ill at the cottage at Pond's Cottages, within a short interval of one another. The symptoms that the surviving accounts describe, vomiting, severe abdominal pain, prostration, were consistent with several gastric disorders that were common in the rural population of the period, and were attended in this household, as in many others, by the local medical practitioner, Dr. Hawkes of Saffron Walden. The available record does not preserve a precise day-by-day account of the boy's illness. What the record establishes is that both children died within a short interval of one another in the same month. That Dr. Hawkes issued a death certificate in respect of each, attributing the cause of death to English cholera, a term used at the period to describe a severe gastric illness distinct from the Asiatic cholera, then beginning to appear in epidemic form, and that the two boys were buried together in a single coffin in the churchyard of St. Mary and St. Clement at Clavering. No inquest was held, no suspicion attached, at this stage, to any person in the household. The second episode opened in the summer of 1846. Lydia Taylor, a young woman of the parish, had given birth, out of wedlock, to a boy whom she had named Solomon. The infant had been healthy through the early weeks of his life. On a day in June 1846, by the testimony Lydia Taylor would later give at the proceedings, Sarah Chesham had attended upon her at her lodgings and had fed the infant with rice pudding and with apple turnover. The infant had deteriorated within hours. He had died the same day. An inquest was held. The body was forwarded, in due course, to a leading toxicologist of the period, Alfred Swain Taylor of Guy's Hospital, no relation to the infant's mother, for analysis. The remains of the two Chesham children, Joseph and James, were also at this stage exhumed from the churchyard at Clavering and forwarded for analysis by the same toxicologist. The findings were entered into the record and would become the substance of the 1847 proceedings. The third episode opened in the year 1849 and ran through the spring of 1850. Richard Chesham, the husband, had at some point in 1849 begun to suffer from a deterioration of his health that included symptoms of pulmonary disease and recurring bouts of severe stomach pain and sickness. He was at this stage in his early 40s. Pulmonary tuberculosis, then known as consumption or phthisis, was a common cause of mortality in the labouring population of the period, and was, in his case, the underlying condition that the medical evidence subsequently identified. During the period of his illness, his wife was constantly in attendance upon him. She prepared his food. She fed him milk thickened with rice and with flour. The surviving accounts record that she would not permit any other person to feed him during this period. He died on a day in May 1850 and was buried at Clavering on the 24th of May of that year. He was, at the date of his death, 43 years of age. The method by which the prosecution would in due course argue that arsenic had been administered in each of the three episodes was the simplest method available within the domestic economy of the household. Arsenic, in the form of arsenious oxide, was a white, nearly tasteless powder, readily soluble in hot liquid and indistinguishable by the unaided eye from flour or from the finer grades of sugar. The method is described in some of the secondary accounts as the introduction of the powder into the prepared food of the victim. This is not confirmed with certainty by the primary materials in every case. What the surviving record does establish is that, in the case of Richard Chesham, the police, on searching the cottage after his death, recovered a sack of rice from which his wife had been feeding him, that the sack was forwarded for analysis, and that the analysis established the presence of arsenic in quantities visible to the unaided eye. The sack, that had stood against the inside wall of the kitchen, had been entered into the formal record of the case. The convergence of the three episodes into a single line of inquiry occurred in stages, and the procedural history of the case must be set out in some detail. The deaths of Joseph and James Chesham in January 1845 had not, of themselves, prompted any official inquiry. Dr. Hawkes had certified the cause of death in each case as English cholera. The boys had been buried, the certificates had been entered into the records of the parish, and no further action had at that stage been taken. The household had returned, so far as the surface of its life was concerned, to its previous condition. It was the death of the infant Solomon Taylor in June 1846, and the statement made by his mother, Lydia Taylor, that brought the matter to the attention of the authorities. Lydia Taylor stated that her infant son had been in the company of Sarah Chesham on the day of his death, that he had been fed by her with rice pudding and apple turnover, and that he had died within hours. An inquest was opened. The body of the infant was forwarded for analysis to Alfred Swain Taylor, the toxicologist of Guy's Hospital, whose work on the medical jurisprudence of poisoning had by that date already established him as the leading authority of his profession in England. The analysis returned, in respect of the infant Solomon Taylor, no evidence of poisoning. The cause of his death was not, on the medical evidence, established as arsenical. The inquiry, however, did not stop with this result. The local magistrates ordered the exhumation of the bodies of Joseph and James Chesham from the churchyard at Clavering, and the remains of the two boys were forwarded to the same toxicologist for the same analysis. The findings in their cases were of a different character. Alfred Swain Taylor reported that both bodies contained fatal doses of arsenic. The cause of death in each case was, on the medical evidence, arsenical poisoning. Sarah Chesham was, on the strength of these findings, taken into custody. The proceedings of March 1847 followed. The acquittal of Sarah Chesham at the proceedings of 1847 on each of the three indictments laid against her did not bring the inquiry to a final end. The press continued, in the years that followed, to attend to her name. The neighbours continued to call out "Sally Arsenic" in the village street. The household at Pond's Cottages continued in its outward course. It was the death of Richard Chesham in May 1850 that reopened the inquiry, and the reopening was the work of the local police, whose suspicions, attached to the household by the events of the preceding years, prompted an order for an autopsy. The autopsy was conducted. Traces of arsenic were found in Richard Chesham's body, in quantities that were not, in themselves, sufficient to have caused death. The cottage was searched. The officer who conducted the search was Superintendent John Clark of the Newport Police Station, then the senior officer of the local constabulary. He recovered, among the household provisions, a sack of rice from the kitchen and the contents of the deceased's stomach as recovered at the post-mortem. Both were sealed and forwarded to Alfred Swain Taylor at Guy's Hospital for analysis. The analysis returned the presence of arsenic in both. The rice was reported as heavily contaminated, with the quantity of arsenic estimated at some 16 grains in the sack as recovered. The figure may be put in perspective by reference to the medical jurisprudence of the period. 2 or 3 grains were sufficient to kill a healthy adult. The police also took statements from the neighbors and from the persons who had attended at the cottage during Richard Chesham's last illness. The statement that would become the principal evidence against Sarah Chesham at the trial that followed was the statement of one Hannah Phillips, a woman of the parish, who reported a conversation she had had with Sarah Chesham. The substance of the conversation, as Hannah Phillips would later give it in court, was that Sarah Chesham had offered to assist her in poisoning her own husband and had spoken of her plans to poison her own. This statement, if accepted by the jury, would establish what the medical evidence alone could not: the disposition of the accused and her own description of her own intent. A coroner's jury, sitting in the immediate aftermath of Richard Chesham's death, had at first declined to charge Sarah Chesham with murder. The police continued the investigation notwithstanding this preliminary refusal. The evidence accumulated. Sarah Chesham was, on the strength of the rice, the body and the statement of Hannah Phillips, taken into custody and committed to await trial at the Essex Lent Assizes of 1851. The arrest was made by the local police, acting upon the order of the magistrates. No alias was used. She was, by the date of her arrest, the most well-known woman in the parish of Clavering, and her name was already attached to the proceedings before any formal step had been taken. The principal medical witness in the case of Sarah Chesham was Alfred Swain Taylor, of Guy's Hospital, professor of medical jurisprudence and the leading toxicologist of his generation. His reports formed the substance of the medical evidence at each of the proceedings, both those of 1847 and those of 1851. The condition of the materials he received and the limitations of the analyses available to him in this period must be borne in mind in any consideration of the evidence as he gave it. In respect of the 2 children, Joseph Chesham and James Chesham, whose bodies had been exhumed in 1846, more than a year after their burial, Alfred Swain Taylor reported the presence of arsenic in the stomachs of both, in quantities he characterized as fatal. The method of analysis available to him was the Marsh test, developed in the 1830s by James Marsh, which permitted the detection of arsenic at quantities well below the lethal dose. The condition of the remains, after 18 months in the soil of the churchyard, imposed limitations on the examination of soft tissue, but the chemical analysis was held to be reliable and was entered in the formal record. The identification of the remains as those of Joseph and James Chesham was, in the case of children buried in a single coffin and exhumed from a known and registered grave, taken as established by the convergence of the burial register, the location of the grave, and the family's identification. In respect of the infant Solomon Taylor, whose body was examined in 1846, Alfred Swain Taylor reported no evidence of poisoning. The cause of death was not established as arsenical. This finding, and the resulting acquittal at the proceedings of 1847, must be noted in any account of the case. The conviction the public believed Sarah Chesham deserved did not, on the medical evidence, attach in respect of the infant. In respect of Richard Chesham, the husband, whose body was examined in May 1850, Alfred Swain Taylor reported the presence of arsenic in the stomach contents and in such portions of the body as were submitted to him, but in quantities below the dose conventionally accepted at the period as sufficient to cause death. The underlying condition of the deceased was pulmonary tuberculosis of long standing. The medical question presented at the trial was therefore the question of whether the small quantities of arsenic found in his body were the cause of his death, the contributory cause of his death, or an incidental finding bearing no causal relation to it. The prosecution would in due course argue that the arsenic had been administered in small doses over an extended period, sufficient to weaken the body in its resistance to the tuberculosis, without itself crossing the conventional lethal threshold at any single point. In respect of the rice recovered from the cottage, Alfred Swain Taylor reported the presence of arsenic in quantities far in excess of any natural contamination. The figure of 16 grains in the sack, as recorded in the surviving accounts, exceeded by several multiples the dose conventionally accepted as sufficient to kill a healthy adult. The arsenic was reported as visible to the unaided eye when the rice was examined in good light. Two limitations of the medical evidence must be noted. The first is that no witness in any of the proceedings gave direct testimony of having seen Sarah Chesham administer arsenic to any of the persons whose deaths were the subjects of the indictments. The medical evidence established the presence of the substance in the bodies and in the rice. It did not establish the act of administration. The second is that rice, even where no contamination has occurred, contains naturally occurring arsenic in trace quantities, a fact known in the chemistry of the period in general terms, though not at the level of precision available in the modern literature. The quantity recovered from the sack at Pond's cottages was, however, of an order that no naturally occurring contamination of rice could plausibly explain. The medical evidence was, on this point, taken as established. The case of Sarah Chesham came before the Assize Court at Chelmsford on two separate occasions, in 1847 and in 1851. The first set of proceedings produced acquittals on each of 3 indictments. The second set of proceedings produced a conviction. Both must be set out. The first set of proceedings opened on the 11th of March 1847 at the Lent Assizes of the County of Essex, held at Chelmsford. Sarah Chesham was indicted on 3 counts: the wilful murder of Joseph Chesham, the wilful murder of James Chesham, and the wilful murder of Solomon Taylor. The court was constituted in the customary form, presided over by an assize judge sitting in commission. The case attracted the attention of the London press, and the proceedings were reported in the Times and in the provincial newspapers as they ran. The medical evidence of Alfred Swain Taylor was given in respect of each indictment. Evidence as to the presence of various poisons in the cottage at Pond's cottages was given by the local police. Witnesses were called and examined. The case for the Crown was concluded. The jury in the case of Joseph Chesham retired and returned, after a deliberation of approximately 10 minutes, a verdict of not guilty. The foreman, in delivering the verdict, is reported in the press accounts as having said that the jury had no doubt that the child had been poisoned, but that they did not see any proof of who had administered the poison. The trial of the indictment in respect of James Chesham followed and produced the same result. The trial of the indictment in respect of Solomon Taylor followed on the next day. On this indictment, the judge directed the jury to acquit on the grounds that the medical evidence had not established that the infant had been poisoned at all. Sarah Chesham was discharged. She returned to Clavering. The discharge of 1847 was met, in the public press, with a chorus of dissatisfaction. The Times described her as an accepted and reputed murderess, and ran articles to the effect that she had been offering her services as a poisoner to others for a fee, and that the neighbours had known of her activities and had declined to inform against her. These reports must be treated as the press of the period treated such matters, with reserve as to particulars. The substance of the allegations was not tested in any court, and the surviving primary materials do not establish that she had been operating as a paid poisoner at any time. What the record does establish is that the public belief in her guilt, formed in the first proceedings, attached to her name through the years that followed, and was present in the public mind when the second proceedings opened. The second set of proceedings opened at the Essex Lent Assizes in March 1851. The court was again the Assize Court at Chelmsford. The presiding judge was John Campbell, 1st Baron Campbell, then Lord Chief Justice of the Queen's Bench, a peer of high standing in the legal profession of the period, and noted in the literature for a forceful manner with juries that drew, during his career, repeated criticism from observers of the bench. The prosecution was conducted by Messrs. Bodkin and Clark. Sarah Chesham, the defendant, had no counsel of her own. The court appointed counsel to represent her, but she was not, in the conduct of her defense, in the position of a defendant fully equipped to test the evidence laid against her. The indictment was for the felonious administration of poison to her husband, Richard Chesham, with intent to kill him. The charge was attempted murder, not murder. The medical evidence had established that the quantity of arsenic in his body was not, in itself, sufficient to have caused death, and the underlying disease, tuberculosis, provided an alternative or contributory cause that the prosecution had not sought to displace. The punishment on conviction would nonetheless be the same as on a conviction for murder, death by hanging. The evidence for the Crown was presented in the customary order. The discovery of the death and the calling of the post-mortem were established by the local police. The medical evidence of the post-mortem and of the analysis of the rice was given by Alfred Swain Taylor. The domestic history was given by Dr. Hawkes of Saffron Walden, who described the long course of Richard Chesham's illness and the conduct of his wife throughout it, including the fact that she had fed him milk thickened with rice or with flour and would not permit any other person to feed him. The statement of Hannah Phillips, the woman of the parish to whom Sarah Chesham had spoken of her plans, was given in evidence. The case for the Crown was concluded. Sarah Chesham, in her defence, made what the accounts describe as a lengthy and rambling statement, the substance of which was the protestation of her innocence. She did not, on the surviving accounts, succeed in displacing the medical evidence, the statement of Hannah Phillips, or the construction the prosecution had placed upon the conduct of the household during her husband's illness. The court-appointed counsel had little to advance against the weight of the Crown's evidence. The jury retired and returned, after a short deliberation, a verdict of guilty. Mr. Justice Campbell, in passing sentence, addressed the prisoner. The surviving accounts record that he appeared overcome with emotion and had some difficulty pronouncing the death sentence. He spoke to the prisoner of the gravity of the verdict and of the proceedings that had brought her before the court. He pronounced the formal sentence, that she should be taken from the place of trial to a place of execution, and there hanged by the neck until she was dead. Sarah Chesham was returned to Springfield Prison at Chelmsford to await the carrying out of the sentence. It must be noted, in the available record, that observers at the time and historians since have raised concerns as to the conduct of the proceedings. Sarah Chesham had no counsel of her own choosing. She was not in a position to call her own witnesses. The press, in the years between her acquittal of 1847 and her conviction of 1851, had repeatedly named her as a poisoner in the course of reporting on other cases, and the jury at the Essex Lent Assizes of 1851 cannot be presumed to have been unaware of that body of reporting. Mr. Justice Campbell had, during the trial, made statements that observers interpreted as accusing her of serial poisoning, notwithstanding the acquittals of 1847. These features of the proceedings are not the addition of modern revisionism alone. They were noted at the time. The proceedings, nonetheless, returned the verdict. The sentence was carried out on Tuesday, the 25th of March, 1851, just after 9 o'clock in the morning, at Springfield Prison in Chelmsford. The prison had been built in 1825 and stood on Springfield Road, with the gatehouse forming the central feature of the frontage. The gallows had been erected on the flat roof of the gatehouse on the preceding day. The execution was a public one, conducted in the customary form of the period in front of the prison. Public hangings would continue in England and Wales until the Capital Punishment Amendment Act of 1868 removed them within the walls of the prison. The proceedings of 1851 thus fell on the public side of that statutory line. The executioner was William Calcraft, then in middle career, who had taken up the office of Common Hangman of London and Middlesex in 1829, and who, by the date in question, had become the senior hangman of England, in regular employment by the prison authorities of several counties. Calcraft was, by 1851, the customary executioner for the assize executions of Chelmsford. He had carried out the public executions at Springfield Prison since the early 1830s. Sarah Chesham did not go to the scaffold alone. The same morning was appointed for the execution of Thomas Drury, a man convicted at the same assizes of the murder of Jael Denny, his pregnant former lover, whom he had strangled in a field at Doddinghurst, near Brentwood. The pair were brought from the condemned cells to a room below the gallows shortly before 9 o'clock. They were pinioned by Calcraft. They were taken up to the platform on the roof of the gatehouse. They were hooded and noosed. Calcraft descended to operate the drop. The drop fell. Sarah Chesham's struggles, as the accounts report, lasted some 3 minutes. Thomas Drury's struggles, by the same accounts, lasted only briefly. A crowd estimated by the contemporary reports at between 6,000 and 7,000 stood before the prison to watch. The reports describe the audience as composed in its majority of women. Several London pickpockets were noted as operating within the crowd. The proceedings followed the customary order. The bodies were left suspended for the customary hour before being taken down. The officially present at the execution were the persons whose presence was required by the practice of the period: the prison governor, the chaplain, the under-sheriff of the county, the prison surgeon, and the executioner himself. Such accounts as survive of the demeanor of the condemned woman, as given by the prison officials and reported in the press, describe her as having protested her innocence to the last. These accounts, taken at any time from prison officials, are not always reliable in their particulars, and must be treated with such reserve as the source warrants. No confession was made on the surviving record before the carrying out of the sentence. She did not confirm, in any formal statement, the matters of which she had been convicted, nor any of the matters of which she had been acquitted. She was conveyed, after the execution, to Clavering for burial. Because she had been convicted of administering poison with intent rather than of murder, the requirement that the bodies of murderers be buried within the walls of the prison did not apply, and her son was permitted to claim her body and to carry it home. She was buried in Clavering churchyard at 7 o'clock that evening in the presence of more than 150 spectators without any religious ceremony. There is no entry in the burial register of the parish. The formal proceedings against Sarah Chesham were, with that interment, concluded. The case of Sarah Chesham entered the historical record by several routes, and the contours of its preservation must be set out. In the immediate aftermath of the proceedings, the case was the subject of intense press attention. The London newspapers had followed the trial as it ran and reported the verdict, the sentence, and the execution. Provincial newspapers throughout the country reproduced the accounts, broadside ballads of the kind printed on cheap paper and sold for a penny at fairs and on street corners, circulated in the weeks following the execution. One of the surviving broadsides, Sarah Chesham's Lamentation, is held in the collections of the British Library. The reports formed part of a wider moral panic in the late 1840s and early 1850s concerning the use of arsenic as a domestic poison, a panic that the press itself had a hand in fostering, and in which the figure of the woman poisoner had acquired a particular cultural weight. The institutional consequence of the case was the Sale of Arsenic Act 1851, which received the royal assent in June of that year, in the weeks following Sarah Chesham's execution. The Act had been drafted in the preceding period, partly in response to the case of Mary May, the Essex poisoner executed at Chelmsford in 1848, and partly in response to the general anxiety concerning arsenic that the Chesham case and others like it had fostered. It was introduced into the House of Lords by the Earl of Carlisle. Its principal provisions required the sellers of arsenic to keep a register, to record the name of the buyer, the quantity sold, and the purpose of the purchase, required the buyer to sign the register, restricted sales to persons known to the seller, or to persons accompanied by a witness who could vouch for them, required that arsenic sold in small quantities be coloured with soot or with indigo so as to render it visibly distinct from flour and from sugar, and permitted the sale of uncoloured arsenic only in quantities of 10 pounds or more. A clause that would have prohibited the sale of arsenic to women altogether was, in the course of the parliamentary proceedings, dropped from the bill. The Act stood, in its essential provisions, as the foundation of the law regulating the sale of arsenic in England for the remainder of the 19th century. The case has been treated, in the scholarly literature of the modern period, in the work of social historians of the Victorian poor, of legal historians of the assize courts, and of cultural historians of crime. James C. Wharton, in his volume The Arsenic Century, How Victorian Britain Was Poisoned, at Home, Work and Play, treats the Chesham case at length and places it in the wider context of the domestic arsenical poisonings of the period. The work of K.D. Watson and of L. Bartrip has placed the case in the history of the Sale of Arsenic Act. The Saffron Walden Historical Society has produced its own account, drawing on the local records and on the depositions held in the Public Record Office. The case has been included in the standard reference works on capital cases of the Victorian period and in the registers of the executions carried out at Chelmsford. In 2019, the BBC programme Murder, Mystery and My Family examined the case of Sarah Chesham with the assistance of legal and medical advisors and concluded that the conviction was unsafe by the standards of modern evidence and procedure. The programme noted the absence of any direct witness to the administration of arsenic, the possibility that the symptoms recorded in Richard Chesham's case were attributable to the underlying tuberculosis, the natural occurrence of arsenic in rice, the conduct of Mr. Justice Campbell at the trial, and the absence of effective counsel for the defence. In 2020, the matter was referred to the Criminal Case Review Commission with a view to a posthumous pardon. The status of that referral, at the date of this account, requires verification against the published proceedings of the Commission. The victim of the proceedings, in the historical literature, has been the man whose death gave rise to the indictment of conviction, Richard Chesham, the labourer of Clavering. Beside him stand the names of the three earlier deaths, Joseph Chesham, James Chesham, and Solomon Taylor. In the modern accounts of the case, the woman has stood more largely than any of them. The trial, the execution, the broadsides, the Sale of Arsenic Act, all attached to her name. The victims, in the conventional treatments of the case, appear as the occasions of her trial rather than as persons in their own right. The two boys, in particular, appear in most accounts as a single phrase, her two sons. The infant Solomon Taylor, in many accounts, is not named at all. The men and the women of Clavering, who knew the household and who spoke at the inquest and at the trial, are recorded chiefly through the depositions held in the archives at the Public Record Office, where they survive as papers and not as figures. The record, having received their names at the proceedings, has not always preserved them in the accounts that the proceedings produced. The cottage at Pond's Cottages no longer stands in the form it took in the 1840s. The parish church of St. Mary and St. Clement stands. The grave of the two boys is not separately marked. The grave of Sarah Chesham, dug at 7 o'clock in the evening of the 25th of March, 1851, in the unconsecrated portion of the churchyard, is also not marked, and has no entry in the burial register. Springfield Prison stands on Springfield Road in Chelmsford to the present day, the gatehouse from which she was hanged having been altered in subsequent reconstructions, but in its outward situation still recognizable. The case of Sarah Chesham was the single matter examined in this account. The conviction was entered. The execution was carried out in 1851. The case became part of the national record. It has not left.